Welcome back to the Constitutional Clarion. This time I'm going to talk about referendum questions again, and that's because a number of people have raised concerns about the form of the question and potential litigation in relation to that. Now, if you were ever going to have a referendum bingo card where you needed to tick off all the various matters that tend to arise in relation to a referendum, well, you would imagine you'd include on that, first of all, a controversy about there being misinformation in the yes-no pamphlet. Here's the latest yes-no pamphlet, because that's traditional. We always have misinformation there. The second thing that you would see would be an argument about the way the referendum question is formed, so what sort of words are used, are particular words pejorative or more likely to cause someone to vote against something. And then the third thing, traditionally, is that you have the last-minute litigation. Yes, and it's always last-minute litigation because if you are actually genuinely concerned about the issue, you might have raised your litigation and commenced it, when you knew the referendum was going to be held. But no, people tend to always raise their litigation in the last week before the referendum is held because you can get breathless media reporting of, shock horror, referendum may not be held, court might hold it all invalid. Yes, it is something that people tend to do. And, my bet is that there are people sitting there right now going, waiting to commence my litigation and cause a drama and get myself lots of publicity. The main aim, of course, apart from getting yourself lots of publicity, is to create that atmosphere of drama and confusion and risk, all of which is intended to cause people to vote no. Okay, so there's my prediction for what it's worth. Any event, let's have a look at some of the arguments that are kicking around in relation to this. So in this video, I'm going to look at two of them. The first argument is the one that the referendum would be invalid unless it had on the ballot paper itself a full copy of the amendment that was being voted on. So that's argument number one, and there's already been an abortive attempt to bring that one. Argument number two, slightly more sophisticated, and that is that the ballot paper, in terms of the question that's on it, has to include in that question whatever detail it is that you think is most objectionable in the referendum. So we'll talk about that a little bit later in this video. So they're the two things I'm going to talk about here. Okay, so good guide here is to go back and have a look at history. So historically, has the referendum amendment ever been actually included on the ballot paper? And the answer to that is no. Not once, never. Now you might ask yourself why. Well, first of all, section 128 of the Constitution, which sets out the rules for voting in a referendum, says that what's put to the people in a referendum is the proposed law. And it's the proposed law that contains the amendment. So people are voting to approve a proposed law, and that proposed law is identified by reference to its title. Now, a lot of this I discussed in a previous video, so you might remember from then that every law, every statute, when it's enacted, has a short title and a long title. So the short title is just that. That's what you call it. It's the name of the thing. And the long title is a little bit more descriptive. It gives the scope of the relevant bill as it's passing through Parliament. It's used in parliamentary procedure to confine any type of amendments that are made in the course of going through Parliament to make sure they fit within the scope of what the bill is about. So the long title is a little bit more descriptive. Now, interestingly, from the very first referendum, initially they used the short title for the purpose of identifying the proposed law when holding a referendum, so not the long title. And let's just give you two examples of the first couple of amendments that were made. So if you go back to 1906, you'll find a referendum where the question was this: do you approve of the proposed law for the alteration of the Constitution entitled Constitution Alteration, Senate Elections, 1906. All right, that's all it told you. It had something to do with Senate elections. That tells you nothing else. Okay, that's 1906. And in 1910, the question was, do you approve of a proposed law for the alteration of the Constitution entitled Constitution Alteration, State Debts, 1909? Now, both of those referendums were put and both of them were actually passed. And what's also interesting is that the person who was Prime Minister at the time was Alfred Deakin. Now, Alfred Deakin was one of the framers of the Constitution. In fact, he was one of the people who pushed really strongly for the people to be able to vote in a referendum for changing the Constitution. So Section 128 is basically his fault. And I reckon he probably knew what was intended with Section 128. And so when he put up his referendums, and he didn't put the actual terms of the amendment on his ballot paper, I'm guessing he pretty much knew what he was doing. Now, these short titles were used in referendums to identify the proposed law all the way up until the 1967 referendum. And from 1967 onwards, we've swapped to using the long title to identify the proposed law. And it's actually instructive to look at the 1967 Aboriginal referendum to see what its question was. So let me read it to you. It said this: do you approve the proposed law for the alteration of the Constitution entitled An Act to Alter the Constitution so as to omit certain words relating to the people of the Aboriginal race in any state so that Aboriginals are to be counted in the reckoning of the population? Okay, that was it. That was the question. Can you see something a bit wrong there? It didn't actually really describe the fact that what it was doing was expanding the Commonwealth's legislative power. Commonwealth had legislative power to make special laws with respect to the people of any particular race, except for Aboriginal and Torres Strait Islander peoples, and that exception was being removed here, so that the Commonwealth was being given greater legislative power so it could legislate in relation to Indigenous Australians. But curiously, that's not even mentioned in the question. So yes, the question was misleading. And look, frankly, when people look back at the 1967 referendum, most of them think it did something completely different, like voting rights for Aboriginal people or citizenship or all sorts of other weird stuff, when it didn't do any of that at all. Any event, 1967 question, long title used, but nonetheless didn't really at all have even major detail included in the question. All right, let's move to more recent times. What's the most recent referendums we've had? Well, 1999. And they were referendums under John Howard, so a coalition government. So the 1999 one on the preamble, what was its question? Well, it said, a proposed law to alter the Constitution to insert a preamble. Do you approve this proposed alteration? Okay, no copy of the preamble put in on the ballot paper. You just get asked, do you approve of the law to put in a preamble? And as for the 1999 Republic referendum, did it include on the ballot paper the text of all the various little changes that were, and big changes that were going to be made to the Constitution? Well, the answer is no, again. And there's actually, this example shows you why the entire proposition is completely bonkers. Okay, so here's my copy of the yes-no pamphlet from back then. And if you want to actually see what the amendment was, because the amendment involved, for example, changing every reference to the President of the Senate so that the President of the Senate didn't get confused with the President of the Republic, they had to make a whole lot of amendments. So in the end, what they did was that they actually put a copy of the Constitution in the back of the yes-no pamphlet and then marked it up so that all the various changes that were being made could be read. So you could see what was being crossed out with things being crossed out and what was being put in with things being underlined. And so have a look at this. How many pages of this would you have to put onto your ballot paper? Oh yeah, there's more. And there's more. And look, there's a whole lot of stuff here about the president, and there's more. And there's more. Oh yeah, more. And yeah, okay, we can keep going for this for a long time. Exactly how big would you have to make your ballot paper to do this? So big that you couldn't print it. Why do I say that? Well, back in the day when I was working in the New South Wales Cabinet Office, we did have a problem with the, you might remember, the tablecloth ballot paper. And I was told then by the Electoral Commissioner that if one more party had registered to go on to the ballot paper, there were not machines that could cope with a ballot paper big enough to run the election that existed in the country. So bottom line is, it's just completely bonkers to say that you have to put the actual amendment onto the ballot paper, because in many cases it would just be physically impossible for the ballot paper to, in any reasonable way, contain that amendment. The other thing to point out here is that Section 128 of the Constitution specifically leaves it to Parliament to make laws about how the referendum is to be held. And it says this: when a proposed law is submitted to the electors, the vote shall be taken in such manner as Parliament prescribes. Now, Parliament has enacted a law about the manner for doing this, and that's the Referendum Machinery Provisions Act of 1984. There was a previous law as well before that. And it requires the ballot paper to identify the proposed law by reference to its title. So the law itself says you don't stick the amendment onto the ballot paper, you identify the proposed law by reference to its title, which could be the long title or, pre-1967, the short title. Has there ever been any litigation about this? Well, actually there has, but at the state level. So the New South Wales Constitution also provides for certain constitutional changes to be put to the people in a referendum. And its provisions are actually based on the Commonwealth Constitution in Section 128. So there's very close similarity between them, as indeed the courts have noted. So in 1933, a fellow named Albert Piddington challenged a New South Wales referendum, which was about reforming the Legislative Council of New South Wales on a number of grounds. Now, Piddington, for the legal nerds out there, will be remembered as the man who in 1913 was appointed to become a judge of the High Court of Australia, but was subject to such enormous loads of criticism because people thought that he wasn't really qualified and up to the job that he resigned before he ever sat. So the unhappy Piddington comes back to the courts as a barrister and challenges in 1933 this amendment that changed the New South Wales Constitution in relation to a form of indirect election of the Legislative Council. Now, Piddington argued that the referendum was invalid because copies of the amendment were not handed to voters as they went into the polling booth. And they were also, he argued, not adequately displayed elsewhere so that people could not genuinely know and make a free vote at the time of the referendum. Now, the Supreme Court rejected that argument. It pointed out that, first of all, there was a period of at least 2 months after the referendum passed the Parliament in which people could educate themselves about the nature of the proposed amendment. So, for example, they could, read the newspapers, they could go to town hall meetings, and it was displayed in public places like courthouses, etc., if you wanted to go and read the amendment. The Supreme Court also pointed out that the New South Wales Constitution conferred on Parliament the power to make rules for how the vote in a referendum was to take place, just as the Commonwealth one does. And that these rules were on all fours with those used in federal referendums. And they included exhibiting the proposed law in various places around the state. And the court concluded this: in our opinion, even on the assumption that there is a statutory implication that some provision should be made to enable the electors to acquaint themselves before the day of voting with the provisions of the bill on which they are required to express their opinion, it is for the legislature and the legislature alone to determine what public notice of the terms of the bill is sufficient for that purpose. Now, another challenge was made to the same referendum later, and unsurprisingly, the New South Wales Supreme Court reached exactly the same conclusion. But on this occasion, it then went to the Privy Council on appeal. And the Privy Council also agreed with the New South Wales Supreme Court. It said that the Constitution simply required the people to vote with respect to the proposed law, and that there was no obligation to put a copy of the referendum proposal before the elector when they voted. And it said this: it is for the legislature to determine what is sufficient to bring the meaning and effect of this bill before the electorate. So in short, a copy of the amendment itself did not have to be provided at the polling booth or indeed included in the ballot paper. The people had plenty of time to educate themselves before the referendum, and it was a matter for Parliament to set those rules about how the referendum was to be conducted. And it's therefore, again, unsurprising that when someone actually did seek to issue a writ in the court challenging the voice referendum for not including the amendment on the ballot paper, the registrar refused to register that writ, and a justice of the High Court ordered that it should not proceed unless a justice of the court gives permission to do so under a rule that deals with frivolous and vexatious proceedings. Now, the second question that I want to address is the question about the actual words used in the question and whether or not they adequately address the substance of the change to be made. So, does the question have to reflect the nature of the amendment, or could it be about something completely different? So, for the current referendum, the short title of the bill is Constitution Alteration Aboriginal and Torres Strait Islander Voice 2023. Right, that's its short title. Its long title is A Bill for an Act to Alter the Constitution to recognise the First Peoples of Australia by establishing an Aboriginal and Torres Strait Islander voice. Now, the question on the ballot paper will therefore say, and this is what's required by the Referendum Machinery Provisions Act, a proposed law to alter the Constitution to recognise the First Peoples of Australia by establishing an Aboriginal and Torres Strait Islander voice. Do you approve this proposed alteration? Now, for example, what if the Parliament had left the amendment the same, so it was still an amendment about the voice, etc., but had actually given it a completely misleading different title, like A Bill for an Act to Give Everyone a 3-Day Weekend, so that people went to the polling booth and the question they were asked was whether they approved of a law to alter the Constitution to give everybody a 3-day weekend. Now, would that work? And the answer is obviously no. First of all, because the long title of a bill determines the scope of the bill, and any amendments made to it have to fall within that scope. Using a long title that didn't represent what was in the bill at all would be completely unworkable and wouldn't get through Parliament. The second problem is that a grossly misleading question of that kind would be publicly exposed, and it would backfire because people would vote against it accordingly. But if the question generally describes the nature of the change, how much detail of the amendment do you need to put into the question, and what terminology do you use? There's almost always a fight about the terminology, the wording that's used in the referendum, because some wording is more likely to incite people to vote one way or another than other wording. So in 1988, for example, the opposition was outraged that a referendum question, which really dealt with the issue of one vote, one value, instead used the terminology of fair and democratic parliamentary elections in the question. They thought that that terminology skewed the question. The opposition therefore introduced a bill to require the Electoral Commissioner to be the one who determined the wording of the referendum question, and also for there to be appeals against that wording that you could take to the Administrative Appeals Tribunal. Now, the bill failed. It was opposed by both the government and the Australian Democrats, who held the balance of power in the Senate, And the reason for doing that was that they took the view that it was parliamentarians who had to be responsible to the people through the parliament for the wording of the referendum question. And Senator Janine Haynes, who was from the Australian Democrats at the time, said this: if the government is stupid enough to word the question in a referendum in such a way that it leaves itself open to criticism, it, and not some unelected official, should be the one to wear the curry. So basically, it will become sheeted back to the politicians that choose the words. Now, there was also a controversy about the wording of the 1999 Republic referendum. Now, in this case, it was those who were actually in favour of the referendum who were concerned that the Howard government was deliberately manipulating the question in such a way as to get a no vote. So the initial question that was proposed by the Howard government said this: a bill for an act to alter the Constitution to establish the Commonwealth of Australia as a republic with a president chosen by a 2/3 majority of the members of the Commonwealth Parliament. Now, the point of that was that the focus of the question was actually on the method by which the president was chosen. Now, what was going on here was that the Howard government was trying to focus on the method of choosing the president because there were many Republicans who wanted a republic but were opposed to Parliament controlling the election of the president. They wanted a directly elected president. And so this formulation of the question was, at least arguably, designed to provoke them to vote against the referendum. A parliamentary committee noted that there were lots of aspects of the Republic proposal that were left out of the question, such as public involvement in a nominations committee to decide who would be nominated as president, or indeed the powers of the president, which are pretty important, or even the issue of how the president might be removed. But the committee also noted that it would be really problematic and completely unreadable if your question included a whole shopping list of all the various factors that arose in the referendum proposal. And it also noted that to give one of those factors prominence in the question would also give it undue emphasis. And so it preferred to amend the long title in a way that would avoid this complexity. So its proposal was this: that the question would be a bill for an act to alter the Constitution to establish the Commonwealth of Australia as a republic, with the Queen and the Governor-General being replaced by an Australian President. Now, the Commonwealth Government ended up adopting that recommendation of the committee, but then tacking on to the end of it that it was a president appointed by a 2/3 majority of the members of the Commonwealth Parliament. So again, they still wanted to rub the noses of people into the method of election, thinking that that would be more likely to cause the Republic referendum to fail. And indeed, fail it did. Now, criticism has been directed at the voice referendum question because it refers to two elements of the proposal, that is the recognition aspect of it and the creation of a voice, but it doesn't specify, for example, the function of the voice to make representations to Parliament and the Executive. And the argument has been made that that will somehow invalidate the whole of the referendum because it doesn't mention that particular aspect. Would leaving out that one element somehow make the referendum question unconstitutional? Well, again, going back to logic, if it did, it probably means that every single referendum we've ever had, including the successful ones, would all, by that criteria, have been invalid. Many of them, particularly all the ones up to 1967, had virtually no information in the question at all as to what was being decided upon, and even those with using the long titles from 1967 onwards didn't specifically refer to all the main elements of an amendment. I mean, if you go back to the Republic one, for example, it doesn't mention the powers of the president. So why should the powers of the voice be mentioned in this particular referendum? As the Republic Committee noted, the more detail you put in the referendum question, the more confusing it becomes for voters, which makes it far from helpful when it comes to people voting in the referendum. Ultimately, what is required is that the proposed law that contains the amendment is appropriately identified in the referendum question by title. And that's enough. And that's what the courts have said as well. People do have an opportunity today to educate themselves to know precisely what the terms of the amendment are. You don't, like in 1933, have to go and check it out on the wall of a public building. You've all got this pamphlet sent to your home, and in the pamphlet on page 6 it sets out the terms of the amendment so you can read it for yourself. And you should read it. You should give an informed vote. Unlike 1933, it's much easier these days. Not only do we have a written pamphlet, but we also have the internet where you can read it at all, and most importantly, you have the Constitutional Clarion to help you as well. So I hope you found this all quite interesting. I found it interesting researching it as well. To be fair, I'd always known that the long title was used in the question, but I actually didn't know until I went back and looked at all the questions that they use the short title for referendum questions from from the first one, 1906, all the way up to 1967. So I've learnt something too. So thank you again for watching the Constitutional Clarion, and I'll see you next time. Goodbye.